Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everybody in between. My name is Dan Balkaran, as you see on the screen, and I am an employment lawyer at Samfiru Tumarkin, LLP, which, as always, is Canada's leading employee-side employment law firm. A couple of items of housekeeping before we get going. If you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, don't have a lot in the way of questions. Please send them in as soon as you can. I'd like to get through all of them. Not always able to do that. Hoping today to be able to get through all of them. So if you have questions, please send them in. We've got one right now from Richard. His question is, if my ex-employer sent me money for severance, If my ex-employer sent me money for severance on my final paycheck, does that count as accepting a severance package? And if so, can I send it back? I did not sign the severance package offer. Well, you're going to want to look at the numbers here. So there's provincially regulated, well, actually in all terminations, there's going to be a statutory component, mandatory statutory component to your without cause termination that your employer has to comply with. So let's just say you're provincially regulated and you're a 12-year employee. Your employer is going to have to provide you with 8 weeks of pay. It may choose to offer you an additional gratuitous amount in exchange for signing a release of liability. Now, that release would prevent you, it releases the company from all liability to you in the future for any matters arising from your employment. So, in short, if you sign a release in exchange for money above the statutory minimums, then you don't have a claim against your employer for any sort of additional severance. Now, look at the numbers. Was it just the statutory amount? And the statutory amount, if you're provincially regulated, which most of us are, is going to be 1 week per year of service to a maximum of 8 weeks. It's not quite that, but I'm simplifying. If that's what it's for, then it's fine, and you still have a claim to the additional amount. If they sent you the whole gratuitous amount as well, so they said in exchange for signing a release, we're going to pay you X amount over the 8 weeks. There's an argument that could be made that by cashing the check, that you in fact may have accepted it. As a layperson, a non-lawyer, perhaps before you had legal advice, it's pretty easy to argue that you didn't know and you can return the funds. My recommendation to you, because missing from your question is, do you have a claim to a larger amount of severance than what they've sent you? Okay, so my recommendation to you is that you talk to an employment lawyer right away, find out or confirm exactly how much your severance claim is worth, and then you can assess whether or not you want to cash that portion of the check, send it back, hold on to it and not cash it as part of the negotiation process. There are different things you can do here depending on what exactly your severance claim is worth. So I would talk to an employment lawyer right away. If you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, good question. Thanks, Richard. Question from Scotty. I've worked the same shift schedule for almost 30 years, and now my employer wants to change it to something totally different. Is that a constructive dismissal? Oh, that's a great and loaded question. Okay, so I'll just back up to first principles here because this is complicated and I've got to load this in piece by piece here. So if you've been terminated from your employment, you're entitled to notice, which for most of us is going to end up being severance. Severance is pay for your termination if you've been terminated without cause. Okay, and the amount of your severance can be very lucrative depending on if you have an employment contract and your age, length of service, and position. The longer you've been in a given if you have no contract, the longer you've been in a given position, for, or with a given employer for, and the higher your position and the higher your age, the more severance you can get. Okay, so that's sort of ground floor first principle. Now, if your employer has not terminated you, okay, but you can still get to severance, which requires a termination, if your employer, through its actions, has in effect terminated you. And we've probably all heard of this. It's called a constructive dismissal. So that's where the actions of the employer, in effect, are a de facto termination. Now, there are different ways to get there, but the one that Scotty is asking about is if there was change to a fundamental term of your employment that's imposed on the employer that you have rejected. Okay, so classic example: pay cut by 40%, hours cut by 40%, 30%, something like that, where your take-home pay is being substantially reduced. There are other outlier fact patterns cases where your employer moves you to an office that's far away from what was originally contemplated. Okay, so the question here is, can a schedule change be a constructive dismissal? In some situations, it can be. Now, Scotty has worked the same shift for 30 years, which strengthens his argument that shift is a fundamental term of his employment because he's just always done it. Now, it depends what's in his employment contract. He might have a written employment contract that says the employer can do whatever it wants, and it's not a constructive dismissal. But Scotty here, the details matter. So if you were working 7 to 4 and now you're working 8 to 5, it's not going to be a constructive dismissal. Or if you were working Monday to Friday and now you're working Tuesday to Saturday, but it's still day shifts, that's not going to be a constructive dismissal. Now, if it's a substantial change where it's, you were working day shift and now you're working graveyards, and it's a problem for you, you can't handle it from a physical health perspective, it's much more likely that's a constructive dismissal, given that you've worked in that shift for 30 years. But if there's a reason why you can't work this alternate shift, so childcare, parent care, so some people have senior parents who need assistance, that can really strengthen your position. And so I assume, and it's not clear from you asked about constructive dismissal, but it's not clear from your question whether the best outcome for you is just to continue to work your regular shift, or it's to get a constructive dismissal, get your severance, and go, right? So both things are potential options here for you. I think you need to talk to an employment lawyer right away. It can be a constructive dismissal. It's hard, and this is just you want to make sure that if you do trigger your constructive dismissal, that there's value to doing so. Like if you trigger a constructive dismissal in your case to get 8 weeks of pay, it's not really worth it. But if you're going after 24 months of pay, that can be worth it, and it might be the only time you're able to move on from your organization with severance. So it's certainly something to consider. But constructive dismissals, and this is for everybody listening, they're too hard. They're too fraught with risk. Do not, if you're thinking that maybe your employer has constructively dismissed you, you certainly could be right, but do not do anything with respect to that without legal advice. You need legal advice through the process. It's too complicated, and get that legal advice quickly, because you have 2 months in BC. It might be as much as 3 months from the date of the unilateral change to a fundamental term of your employment to, in effect, trigger your constructive dismissal. And it's not a hard and fast deadline. There's no law that says you've got 2 months, but that's what's been accepted by the Supreme Court of Canada. So, get legal advice, get it quickly, find out what your claim is worth, assess the nuanced details of your constructive dismissal of your schedule change. Because, without more information, Scotty, is that a constructive dismissal? The answer is maybe, but I would need to know a lot more. And so, but a 30-year employee, you could have significant value to a constructive dismissal if it is one. So talk to an employment lawyer right away. If you want to talk to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. And Scotty, I do a lot of these. If you're in BC, please feel free to contact me. I think the moderator, if you could put my contact on the screen. Only if you're in BC, I'm called here only, but that's something I could certainly assist you with if you have interest in contacting us. So anyway, Scotty, talk to an employment lawyer right away. Okay, I don't know this person's name. Can my employer delay my overtime pay? I mean, no, they're required by it. It depends on your position, if you're entitled to the overtime pay under statute or under contract. But generally speaking, if you're owed wages, you have to be paid it pursuant to, if you're provincially regulated, the precepts of the Employment Standards Act in terms of time to pay your wages. So short answer is no. But longer answer is, what is your recourse, right? So your employer is delaying your overtime pay. Do you really want to bring an employment standards branch complaint? Or, I mean, they're called different things in different jurisdictions, but do you really want to bring in a complaint through the employment standards regime against your employer? It's probably going to sour your relationship with your employer. And so you've got to assess, how much is your overtime back pay worth, and how hard do you want to push on your employer for that money? Like if you're talking about $3,000, I'd probably, and you like your job and you can see yourself having a future there, and then you probably want to just say, hey, you owe me this money, in a cordial way, but in a way that, doesn't upset the apple cart, so to speak. When will I be obtaining this? When will you be paying this? Is it going to be spread over checks, etc., various paychecks? If you bring some sort of tribunal complaint for that overtime pay, no employer likes that. So if you bring some sort of adjudication complaint against your employer, you're probably not going to be with your employer. I mean, they can't terminate you out of reprisal, but they'll figure out a way to get rid of you down the road, more likely than not. And so you have to assess what it is that you want out of your employer and how much it's worth, right? How much the overtime. But listen, if you have overtime, if they owe you $100,000 worth of overtime and they're not paying you, you should talk to an employment lawyer right away and go get that money, right? But because you'll have limitation periods to deal with. I try to give sort of broad advice here because every jurisdiction is different. But in some jurisdictions, if you're only entitled, so let's just say your entitlement to overtime pay is contractual, then you've got 2 years from the date of the overtime not being paid to pursue a court action for that money. But let's just say it's not. Let's just say you don't have a contract, employment contract, or it's not mentioned in the contract, and overtime is not mentioned in the contract, and so your only entitlement to overtime pay comes from the Employment Standards Act. Okay. I don't know what they are in different jurisdictions, but in BC, you've got 6 months to file an Employment Standards Branch complaint to pursue that unpaid overtime, after which time you lose your entitlement to do so. So, if it's substantial overtime amount, you may want to look at that right away. You may even want to talk to an employment lawyer. But if it's not, and you want to stay at your employer and you don't want to rock the boat too much, it could be that just asking your employer for it and following up a few times might be the best way to go. But of course, only you know what your relationship is like with your employer. So I would think about all of that with the question of the overtime pay within that lens. Okay, question from Lucy. My store location is closing and I'm being transferred to another branch. My commute will increase by 40 minutes each way. Could this be a constructive dismissal? Oh, that's a really tough question. Transferring to a new location, if it wasn't contemplated at the time of hiring or the last employment contract that you signed, could certainly be a constructive dismissal if the commute becomes excessive, right? So a 40-minute commute is not excessive, but if you already had a 40-minute commute and now it's an hour and 20-minute commute, it could be excessive. Having to travel 2 hours and 40 minutes each day, that becomes difficult. So I would assess that. I think what makes this tough for your fact pattern here is that what is the employer supposed to do, right? Like it closed the store and it offered you a new position or maybe the same position at a different store. It was doing its best, and I think that from an equities perspective, what's fair in the circumstances, which is really what the courts are. If there's a dispute between two parties, the courts are trying to do what's fair in the circumstances as circumscribed by existing law, which is usually just previous judges trying to do what's fair in the circumstances as directed at some point or at certain points by whatever laws our legislatures have passed. It could be. It could be. You'd want to talk to an employment lawyer right away. If you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. It certainly could be a constructive dismissal. If there's no way, Lucy, that you're going to work at that new store, and you want to see if you can get some severance on the way out the door, I'd certainly encourage you to talk to an employment lawyer. But I think it's a tough one, right? It depends on how long the overall commute is, and whether or not it was contemplated in your employment contract or in your employment contract or at time of hiring. And you've still got this problem where what is the employer supposed to do in the circumstances, right? But it could be. It certainly could be. So I would talk to an employment lawyer as soon as you can. Remember, you've got 2 months from the date of the change to 2 to 3 months, depending on, but to initiate your constructive dismissal, after which time you're deemed to have accepted the change, and you can't go back 6 months later and say, oh, I have the constructive dismissal. The law looks at it and says, well, no, you worked at the new location for 6 months. You agreed, you effectively, through your actions, agreed to the new term of employment, which is the new store. Okay. Lynn asks, can I do anything about my employer, the federal government, for forcing me to get the vaccine? I would have lost my job at that time. Sorry, I don't understand the question. So you got the vaccine, you don't like the medical results? The short answer, I don't practice. Well, that's going to be a occupational health and safety question. And the short answer is probably going to be no. But it's not really an area that I have any expertise in. You may wish to talk to somebody who practices in occupational health and safety if you have injuries and you can medically prove it. But I imagine that that's going to be very challenging to get actual medical records that say that you had injury from the vaccine. If that's not what you're asking, please clarify. If you can, let me know. Ashley asks, if your employer sells the business, and the new owner offers you a lower position, is it considered resigning if you don't accept? Okay, Ashley, that's a incredibly complicated question, and I'm going to give you some pieces of it, but my overall answer is going to be you need to talk to an employment lawyer immediately, like very fast. So your employer, so company A is acquired by company B, okay? And that can happen by a share purchase, which means that company B acquires the ownership shares of company A, which means it acquires all the assets and liabilities. Assets would be like the buildings, the products, the intellectual property, that sort of thing. Liabilities are the debt and employees. Okay, so it is business as usual if it's a share purchase, and if your employer your new employer tries to get you to sign an employment contract, you don't have to sign it. Okay? But if you don't, and they have to give you fresh value for signing it for it to be enforceable. But if you don't sign it, you have to be prepared for the consequences, which could be a termination. Now, if you've got 3 weeks of severance coming to you, why would you do that? However, if you've got 24 months of severance coming to you, makes some sense. Okay. Now, if it's an asset purchase, so what an asset purchase is think about General Electric. General Electric famously was this big conglomerate, and it had various different divisions. You know, it had a nuclear power division, an engine division, a finance division, an appliance division. And let's just say you worked in the finance division. And then General Electric decided one day to sell the finance division to another company, and you go with the finance division because you work there. So General Electric as an entity still exists. It's just that the finance division you work for has now been sold to another entity. Okay, that's an asset purchase. The asset of the finance division was sold. In that particular situation, I mean, I'm going to quote BC, but I think this is law across Canada. But what happens is your employment is extinguished by the asset purchase. Okay. Now, if the employer chooses to have you continue, okay, as an employee, it can offer you a job with the new company, okay. And if it doesn't, this is BC again, but I think it's more or less law across Canada. But if it's just business as usual, you just go working seamlessly from company A to company B, even if it's an asset purchase, and it doesn't draw attention to the fact that it's not honoring your previous length of service, then your previous length of service continues, which matters for a termination because you get the whole credit for the whole history of it in any sort of severance claim. Okay, but if it does say, if it's saying I'm offering you this job, okay, and I'm not giving you credit for your length of service, if you take the job, then you're starting from day one there. Your previous length of service is effectively eliminated. Now, if it's offering you a new position that you don't want, you don't have to take it. But if it is an asset purchase, your claim to severance is against the selling employer, company A. So you have to figure that out pretty quickly because company A might, it's sold and now it's going to get rid of all its assets to the owners of the business, right? So, or all of its assets to the owner of the business. All the money is going to be dispersed away, and so you got to figure this out fairly quickly, and it's very complicated. Now, if you have an entitlement to common law severance, big severance, okay, it's not unfettered, that entitlement. You have to make reasonable efforts to look for replacement employment. Okay? And if you find replacement employment, the kicker is that you're not entitled to double compensation. Any money that you make at a new job is deducted from what you would have made at an old job, at the old job. So what that means is during the severance period. So what that means is if you lose your job today and tomorrow you find a new job that pays you the exact same amount, your claim is worth zero, more or less. I'm vastly simplifying. So if company A, in your case, sells to company B, it's an asset purchase, but company B says to you, you can come work for us, but in this much lesser position. The question is, by not accepting it, have you extinguished your severance claim? And the answer is maybe. It depends on how different those two positions are. So Ashley, when I said it was complicated, it's incredibly complicated. You need to talk to an employment lawyer right away. If you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But actually, you need to talk to an employment lawyer, and you need to do it very quickly. Okay, so of anyone I'm talking to today, you need to talk to one the most, and I would do it as fast as possible. Okay, Richard's back. I've sent a letter to the employer requesting a meeting to negotiate severance. Is there a time frame they must respond to the letter? Well, you can say you want to do that all you want. They don't have to do anything. right? So they can ignore you. They can, and it's hard as an individual employee to negotiate more money. Most of the time, the employer isn't going to budge very much because you don't have the employment law education and legal education to be able to access the legal system in a way that can make things difficult for the employer. So in almost all situations, a lawyer is going to get you a better result from the employer than you on your own, like a much better result. But certainly no, they don't have to negotiate with you. They can just say, this is our offer. And they might just do that. So, but no, there's no, you can put a timeline in there, but it doesn't, if you put a deadline into something, the answer is okay, or what? Like if you don't meet the deadline, what is the consequence? What's the hammer, right? And in your case, are you going to sue on your own? Probably going to want to get a lawyer involved at that point. Okay, question from H. My employer asked me to submit my 2 weeks notice and said they have concerns about my performance. I'm not sure if it's better to resign or wait for them to let me go. I'm worried they would let me go for cause. What should I do? Listen, you need to talk to an employment lawyer right away to assess how much your claim is worth. Because if you don't have an employment contract, if an employer says to you, hand in your 2 weeks notice, what they're really saying is you're fired, but we want you to do it to lessen our burden, right? Our financial burden upon you. Now, they may have cause to terminate you, but which is why you need to talk to an employment lawyer right away, because they could have just cause to terminate you. I don't know what it was that you did or what the performance problems were, if they were properly papered. But what I say, or what I'd argue anyway, is that by saying to you, you hand in your 2 weeks notice, they've already lost the ability to terminate you for cause later, because that's a termination right there, and it wasn't explicitly a cause termination. So H, please talk to an employment lawyer right away. If you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. That's a fascinating little fact pattern, and I wish I knew how that turned out. I'm very curious, but please talk to an employment lawyer right away, H, because you've got a strategic opening there that I think you can make a lot of use of. Okay, I'm not going to identify this last question, or it should be the last question unless another one comes in. I'm not going to identify this person's name because it's unique and it will identify who they are. So I'll just call them E. E asks, how much severance should I get for 15 years employment? My company is offering settlement after I file a claim, file an action for termination of my benefits. I don't know what that last piece means. It could be that you're in Ontario and you're talking about not properly dealing with benefits, getting around a termination clause in an employment contract. But I'm not sure. So it depends if you're entitled to common law severance or not. So there's two types of severance. There's small severance, which is statutory. Everyone gets it automatically. If you're provincially regulated, more or less, it's 1 week per year of service to a maximum of 8 weeks. If you're federally regulated, it's also a small amount, but there's a complex calculation involved based on years of service. If you've been an employee for 12 months and you're not a manager. So there's small severance and big severance. So you're going to get the 8 weeks automatically if you're provincially regulated. The question is, do you have an employment contract that's enforceable that limits you to just that? Or do you get some other contractual amount, or are you entitled to common law severance, which is much closer to 1 month per year of service? Now, that's generally where you want to be. If you can get to common law, you can get as much as 15, 16, 17 months of severance. But, it depends. It varies on jurisdiction. So, for example, Ontario seems to be a lot more generous with severance awards these days than British Columbia and Alberta, for example. So there's a lot of different factors in play. If you're 75, you'll get, and you have a director level position, that's going to get you a lot more severance than if you're 25 and you wouldn't be 25 with 15 years employment. But if you're 35 and you're in a relatively entry level position. So lots of variability. It's impossible to answer that question. It's especially, I can't answer the question without seeing your employment contract, but you're going to want to talk to, I know I said this over and over again today, for a proper assessment of what the actual claim is worth. And this really just goes for everybody, particularly when you have 15 years of service at a particular employer. You're going to want to talk to an employment lawyer because it's impossible. It's too complicated. Employment law is too complicated. You're not going to be able to assess the value of your claim without the assistance of an employment lawyer. So if you need to talk to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, so that's every question. We got all the questions today. Those were really good questions. Lots of constructive dismissal questions. Lots of really interesting questions from all of you. So thank you very much. If you, I think we'll have a session next week, and we do a disability session with Martin Willems. Martin is a disability law partner in the Vancouver office. Excellent disability lawyer. Anyone who has interest in that should attend. I guarantee you'll learn something. And Tuesday, May 21st, 10 a.m., disability Q&A with Martin. Attend if you can. It'll be great. I'll be back here in 2 weeks. Other than that, thank you very much for joining us. You have a safe and wonderful weekend, and we will see you next time.